Good morning. Today is August 28th, 2025, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan. Every Thursday morning, Jean Lawler, David Schraga, and I are delighted to host another webinar for mediators, arbitrators, lawyers, and everybody who negotiates. As you know, there's no charge for these great webinars. We ask people to contribute to a food bank if they like what they see. And ever since we began the series in 2020, our audiences have been so generous in contributing in honor of our great speakers. One of my favorite parts of the program each week is when we announce the running total of just how much our audiences have contributed to date. Jean Lawler, would you please do the honors?
Oh, it's always a pleasure to do this, to these honors. So far, we have been told about $866,392.15 in donations. It just seems like it snowballs every week, $2,000, $3,000, $4,000 a week, whatever it is, 10 cents, $100, $1,000, whatever it is greatly appreciated, and it's making a difference everywhere in the world. So thank you all.
Yes, thank you, Jean, and thanks to everybody, everyone who's contributed and everyone who's presented. Today, we have another terrific presentation for you. We're going to be discussing the role of in-house counsel in mediation. And who better to present on that than Cynthia Randall? Cynthia Randall is Vice President, Deputy General Counsel, and Head of Litigation at Microsoft, where she oversees the defense of commercial and IP litigation, regulatory enforcement actions, and international arbitrations. Cindy has 30 years of complex litigation experience, including in-house roles at Verizon and Cigna, and law firm experience with Dechert LLP and Saul Ewing LLP. Cindy is a graduate of Duke University and the University of Pennsylvania Law School. She serves on Microsoft's Pro Bono Steering Committee, the Class Action Committee of Lawyers for Civil Justice, the Liability Reform Committee of the U.S. Chamber Litigation Center, and the Council of the International Institute for Conflict Prevention and Resolution, lovingly known as CPR. Cindy Randall, please tell us a little bit about the food bank to which you would like people to contribute if they're in a position to do so, and then on with your presentation. Welcome. The floor is yours.
Thanks, Jeff. Thanks, everyone, for joining today. So the organization that I'll hope you'll support is Northwest Harvest. This is an organization here in Washington State that provides an average of 2 million meals each month through a statewide network of food banks, meal programs, and community programs with a focus on nutritious food grown right here in our state. Northwest Harvest also does social justice work to address the conditions that perpetuate hunger and poverty. So a really worthwhile organization, and one that is meaningful to me because in the past, our team has done sort of community bonding and service events that have involved going into the fields and picking squashes and loading up wheelbarrows with the squashes and bringing them back to enormous bins so that this food can then be distributed to people in need. So thanks so much for supporting Northwest Harvest. So as Jeff mentioned, my topic today is the role of in-house counsel in mediation. So to start with, I mean, you've just heard a long bio about me, but as a little bit of relevant background for this purpose, I have been a litigation attorney consistently for 32 years, of which 25 have been in-house at 3 different companies in 3 different industries. And in those roles, I've mediated hundreds of cases with many different kinds of plaintiffs and claims. And so obviously not just at Microsoft, but at my previous employers too. Negligence, wrongful death, medical malpractice, employment, securities, commercial, class actions, antitrust, really the whole gamut. And, I like to attend in person. Even now, I lead a team and the lawyers that work for me are the ones that are handling most of the cases, but I still have my own and I still like to mediate my own cases. It's something I feel very strongly about and really actually enjoy doing. And over the years, I have become a huge fan of mediation because it's a really focused and effective way to get to the heart of a dispute, to evaluate the risks, and to marshal the resources to solve the problem. And it's much more efficient and effective than litigation, which, as we all know, is time-consuming and disruptive and costly, especially for defendants. So, like most litigators, I like to win. Everybody I know and work with likes to win. This is, kind of part of our identity, especially early in a case, like on a motion to dismiss. That's great. Have it all go away before discovery and for very little output. But ultimately, most cases settle. They don't go to trial. And so if a case is likely to settle ultimately anyway, mediation is just a really effective tool for speeding up that process and preserving the company's resources so that it can focus on business and not disputes, which obviously is its purpose. And often, the sooner we do it, the more we benefit. So really, successful mediations are another form of winning. And, it didn't take me that long after I left firm life and went in-house to really start to think of it that way. Wins aren't just wins in court. Successful mediations and mutually beneficial resolutions that save company resources are really another form of winning. And so my team will tell you, I ask them early and often, is now the right time to mediate? Should we mediate this? How can we position this for mediation? What hurdles do we need to overcome so we can tee this up for mediation? And when I'm mediating a dispute as the company representative, I think of that as really a unique role. I'm not just another lawyer in the room. I'm not just there to negotiate. I have a role as representing the company to a person or an entity or a group that is in conflict with the company. And I have the potential as the company voice to soften their view and pave the path towards a resolution. And so I think that's a really important part of my role in the room. It's often important for somebody to make arguments and present evidence and push back and sort of do the litigating, as part of the process. And outside counsel is great at that. And they should be the ones doing that, in my view. And I should stay away from it. They're much better at it. They're much closer to the briefs and the mediation statement and the facts that have been argued. And if I start down that road, it really detracts from my ability to be effective as the company representative. So I try to separate the roles. And in being the voice of the company, I'm mindful of how the company generally presents itself to the world, not just in litigation, not just in disputes, but to the world generally and to its stakeholders as a reasonable and trustworthy entity, as a reasonable and trustworthy business partner, service provider, regulated entity, employer, all those things. And so my voice as the company representative should be consistent with that. I need to be credible and trustworthy. And also, I want to be really focused on driving the discussion forward rather than arguing our position, which, again, outside counsel can do. Because for me, success is going to be resolution. I'm not in that room to win the case. I'm the party that's actually paying for outside counsel and carrying the financial and PR risk and the risk of disruption to our employees and the risk of a nuclear verdict. And so really the company is the entity that stands to benefit most from settlement in a way that outside counsel doesn't, which is not to say outside counsel don't do their best to help us settle cases and meet settlement goals. Absolutely they do. But they don't really benefit from settlements, right? It's not, our financial interests aren't aligned. And they tend to be wedded to the arguments that they believe will win the case, which again is good as advocates. So it's great and very helpful in the negotiation, but I have a different stake in really kind of driving the case towards a resolution. And I think of myself as responsible for driving the mediation. And part of that is really being open to reevaluating the dispute depending on what I learn and how the mediation unfolds, and not being overly wedded to the positions that we had coming into the room. And I think, one of the advantages of that is it gives me a unique opportunity to build trust with the mediator, because we're in a sense on the same side, which is the side of resolution. So how do I make my unique voice heard given the time limitations and the mediation format? This can really be a challenge, actually. I really want to start on the right foot. I want to start the day by meeting the plaintiff in person and speaking to the plaintiff in person. And some mediators are not open to that or aren't interested in that, would prefer to have the parties immediately separated into separate rooms and view any kind of initial meeting as something that might be counterproductive. So I often have to push for that meeting, and to explain why I want to have it, which is not to say, oh, we're going to win this case and you should accept 5 cents. It's so that I can make a very specific sort of statement to the plaintiff, which is to express some empathy and some connection with them. And often mediation is the first time I actually have the opportunity to speak with the plaintiff, whether that's an individual or a representative of a company or any one of another stakeholder group, most of which are important to the company, right? The stakeholder group that the plaintiff represents could be customers, business partners, employees, or shareholders, or any other stakeholder that is important to the company and with which the company had a relationship, because otherwise, why would there be a dispute, right? This is a group that stepping back from the individual dispute does in fact matter to the company. So I like to kick off the mediation by sitting down next to or standing next to the plaintiff and looking directly at them and saying, I want to personally express regret for the circumstances that gave rise to this dispute, and put this dispute in the context of a longer relationship, and to let you know that I'm here to work it out in good faith. So an example of that would be, I'm sorry our business partnership ended badly after many years of success. Your company delivered a lot of value in those years. The company appreciates that, and I'm here in good faith to work it out with you, which is pretty high level, right? It's not obviously an admission of liability, but it's an acknowledgement that there's a dispute, that something that once was going well has gone sideways, and that I recognize that, and I'm in the room to try to resolve it. So, if it's an employee, I'm sorry your employment with the company ended badly. I want to thank you for your contributions to the company during the time you were here, which are appreciated. I'm here in good faith to work it out with you. And, this is a little controversial. I sometimes get pushback from outside counsel about doing it, because there's a little bit of worry that it's going to be interpreted as an admission of liability. But I think it's very straightforward to offer a statement along those lines without any suggestion that we're liable, right? And these are true statements that I can make and deliver credibly and authentically. And they're generally really well received. And it's great to do that right at the beginning, because the goal is to create a clear separation between the litigation and the mediation, right? Between me, the person that they're mediating with, and whatever other person at the company was involved in the circumstances giving rise to this dispute and who's not present. Generally I'd prefer to not have them be there, and who probably bears the blame for the dispute in the plaintiff's mind. And so the plaintiff may be imagining, if they never meet me, that it's that person or a proxy for that person in the other room, and have a lot of negative associations. So I want to kind of reset the relationship with more positive associations. So often if I make that kind of statement, the plaintiff will respond in some meaningful way, either right then or a little bit later, and it really sets the tone for a productive discussion about how to put the dispute behind us. So I'll give you an example of how this works and doesn't work, and how mediation didn't work as well when I was not allowed to do it. About 10 years or so ago, I was mediating with a former employee who'd been at the company for 20 years and whose employment had been terminated for poor performance. And I wanted to speak to him at the outset of the mediation to make the kind of statement I just described, and to say thank you for your service to the company, and I'm here to work this out. And the mediator wouldn't allow it for, reasons that can be that a mediator can have with respect to all disputes, or maybe it was because this particular plaintiff was in a frame of mind that the mediator didn't think it would be productive to have that meeting. So I was precluded from having it and shuttled off into another room, and I really didn't get to see the plaintiff at all, other than to say a brief hello. And we go, 10 hours, and we're still pretty far apart at the end of the day. So we're leaving the mediation, and I see the plaintiff in the hallway. I've seen him for 5 seconds, but I know it's him. Right there he is. He's in the hallway. And I'm thinking, well, this mediation's over, and I'm now outside the jurisdiction of the mediator, and I'm going to go ahead and break the rules. So I walked up to him, and, I was foot away from him, and I made the statement that I wanted to make at the start of the day. And he was visibly moved by it. I mean, didn't say anything right then, but we all left. And the next day, I got a letter from him via email through his counsel, and it was 3 pages long. And it went into quite some detail about how much it had meant to this plaintiff to have worked at the company for most of his career, and how little he felt that the company had valued his contributions or taken them into account when it decided to let him go. And that's why it was so hard for him to resolve the dispute short of trial, and why my statement was appreciated. So I wrote him a letter back. And among other things, I said I had shared his feedback with HR and with the business leadership so that they could learn from this dispute. And then it settled, and it settled within my authority, and it was a good outcome. But I'm sure we could have gotten there a lot sooner if I'd just been allowed to say my piece at the outset. So, but that story is really, that experience has really stuck with me, because clearly the plaintiff had something he wanted to say to the company, wanted to deliver that message. And when he had an opportunity to do that and have it be heard and respected and acted on, that helped him get over the hump to resolve the case on mutually beneficial terms. So that brings me to my next point, which is empathy is part of my job in the mediation. I find it very helpful to empathize with the plaintiff, which involves first listening to them and hearing what they actually are saying, and which is often not directly to me, it's coming through the mediator. But listening to what they're saying, trying to put myself in their position, trying to get information through questions and through interpretation. What's driving this? Besides money, what's causing this dispute? Is it anger, fear, loss of some identity or place in the world, worry about the future, expectations from that person's leadership or family or community? And that helps me think about a solution that addresses those drivers. And so I'm going to keep asking questions while I'm letting outside counsel deliver the arguments and evidence. And David, I see your hand is up, so I'm going to pause, because I do want this to be interactive and not just talk the whole time.
Thanks, Cindy. I mean, maybe I'm not the only, I think I'm probably not the only one here where my mind is blowing hearing you talk about this, because this topic comes up all the time. And, the importance of sort of this type of communication and the resistance to it. And to hear a great story like that is really meaningful. I guess my question for you would be on the flip side. Have you ever had a situation where it backfires, and how do you deal with that? Or, navigating that type of situation where maybe somebody's not receptive to it. I imagine you have a very soft touch in the way you approach it and what you say, but do you worry about that?
Yeah, I mean, it has certainly happened that my initial outreach didn't gain any traction. And so how I think about that then is it's an ongoing conversation, right? I mean, there may be other opportunities over the course of the day to respond to something the plaintiff has brought up, or to maybe there's an opportunity where I could speak to the plaintiff alone again, if it seems like that's going to, get over the hump. And, sometimes it doesn't work. Like, it doesn't work every time, right? And I have a case that's going on now that I've attempted to settle 3 different times. usually, you know, I'm in the room with the principal for the other side, and I'm really trying to connect, and it just hasn't worked for whatever reason. So it's not universally, it's not a magical solution, but even in those hard cases, the conversations are the foundation for some kind of relationship where I'm trying to build credibility with the other side, and to demonstrate that to the mediator too, which I think helps get the mediator invested in helping me resolve the case.
Thank you. I mean, that's kind of breakthrough kind of approach that I think really makes a difference. I see there's another question.
Hey, Steve.
Hi, Cindy, and hi, everyone. Cindy, your point is so important. The mediation belongs to the parties. It doesn't belong to the lawyers, the outside counsel rather, and it doesn't belong to the mediator. But a lot of people come to, the process with a fixed notion of what it should be. So I'm curious what you do, because you've got a lot of experience and you know what you want. What do you do when a mediator, you mentioned a mediator or several mediators have resisted this notion, and maybe outside counsel is nervous or has resisted the notion? How do you handle that?
Well, you heard I didn't handle it all that well, in that one occasion. I just kind of was shuttled off to this room and didn't have a chance, to speak up. So, now I'm a little more alive to that possibility, and I will push back. I'll say, look, I understand why you may not want the plaintiff and me in the same room, because you don't want to, have some kind of interaction that's going to make the plaintiff upset, because that's counterproductive, or make the plaintiff defensive, and waste time, getting over something before we can actually get to talking about how we resolve the dispute. And then I'll say, look, that's really not what I'm going to do. I know what I'm doing here. I've had decades of experience, and I really just want to make a personal connection and assure the plaintiff that, that I'm really here to work it out. That resolution is the goal. And so, some mediators are pretty strict about their protocols, but for the most part, if I say what it is that I'm trying to accomplish, I can get past that. All right, so just picking up where I left off, and this kind of flows from your questions and the point I was making earlier, which is, I think, one of the purposes of mediation for plaintiffs, whether they know it or not, is there's an opportunity for the plaintiff to have kind of a substitute for their day in court, right? An opportunity to tell their story, to have a dialogue about their story, and to get a sense of how their story might play out in front of a jury or in court, and to have the defendant actually really listen to that. And so if that's the experience the plaintiff has in the mediation, then the need to have that day in court may go away. And another interesting case I had a very long time ago, a wrongful death case. I was working for the landline telephone company, and the situation was that plaintiff's 911 call had gone to the wrong town due to a system snafu, and their family member had died before help arrived. So very tragic case. And obviously I started by saying that I was really sorry for their loss, and I really wanted to work it out with them. But what they really wanted from me, as it turned out, was for me to sit down with them and watch this video they had made featuring the family member who had died and all of his contributions to their family and society and his legacy and so forth. And it was 40 minutes long. And so I sat down with them and watched it. And, it was very moving. I had a very obvious sympathetic reaction to it. And then I talked about it with them afterwards. And, that us going through that together made it possible to resolve the case that day. So relatedly, building trust over the course of the day is also, I think, part of my job. And it's easier for me, I think, to build trust with the plaintiff and the mediator than it is for outside counsel for all the reasons mentioned earlier. You know, because I really want it to work out, because again, reasonable settlements make sense for corporate defendants, and we're the big winner when cases settle. So hopefully I have some credibility going in as the result of generally being a reasonable and credible litigant, right? Not taking overly aggressive positions or attacking the plaintiff personally, trying to work out the disputes that come up in the litigation, like scheduling and discovery and so forth, and not going to war over everything. So that's generally how I conduct myself in litigation, and hopefully that carries over to creating some trust with the plaintiff when we go to try to settle the case. Another way to build trust at the outset of the day is to make a really fair opening offer, even if the opening demand is ridiculous, which it often is. You know, I think it's sort of a strategy of plaintiffs' lawyers to make a ridiculous opening demand. And while I find that counterproductive and annoying, I'm not going to come back and say, I'll give you 5 cents, right? I'm going to behave as though we're going to get serious about what the dispute is worth and what a reasonable settlement looks like, and make a fair opening offer, even if that's going to leave me less room to, you know, before I hit my authority or target. And then as the negotiation unfolds, you know, keep asking questions and answering them and giving reasons, right? Reasoned numbers, reasoned moves, not just horse trading, which feels arbitrary. And then, you know, sometimes it's helpful to have a one-on-one with the plaintiff at some point, particularly, you know, if I'm not dealing with an individual whose lawyer may not let me get near them. But if it's another in-house lawyer, for example, we can bond over not wanting to give all our money to outside counsel and share business pressures that we might be under that might be driving our position. And if, you know, trust is established at that meeting, it's really helpful for the rest of the discussion. So, you know, Steve, I think I heard you mention in your when you did this podcast that some lawyers think that mediation is about beating up the other side, right? You know, that they're going to win in mediation by beating up the other side and coming away with this great number. And, you know, I don't see it that way, but you know, one may ask, right? If I'm going to be so nice to the plaintiff, aren't they going to expect me to pay them a lot of money, right? You know, if I come in with this soft touch, is this strategy going to get them to accept less money than they want, which ultimately everybody has to walk away from it with, you know, a result that is mutually beneficial, but not a pure win, right? So how's my strategy going to get plaintiffs to accept less money than they want? Well, it does. In my experience, it does, surprisingly, because getting respect, empathy, and a listening ear from the defendant has value. That has value in the mediation, and it counts for something, and it does tend to make plaintiffs more willing to compromise. But they also need to be persuaded that it's a good and rational idea to compromise. So I try to provide reasons, objective reasons, good reasons, without trying to undermine or beat up the plaintiff. And so, you know, that's compelling substance, not just legal argument. And so, you know, ideally, minimum of time rehashing legal arguments that were already made in the briefs and the mediation statements. Everybody knows what those are, right? To make the most of a short day, I really try to think about what the other side will say to justify its demands, and how to respond in a way that will be meaningful to the plaintiff and not just the lawyers. And, you know, one way that I have found to be effective is to come with like charts and visuals and, you know, more concise and compelling ways to communicate with the plaintiff than legal briefs. And to do that effectively, I think it's important to have a good sense of what the key themes and narrative in our case will be. We were talking before this started about narrative and storytelling, which ultimately is what litigants have to do to be successful at trial, is to have a compelling story. And so having a sense of what that is, what it's going to look like, even very early in the dispute, is super helpful. And having plaintiff hear that or see it can be a real eye-opener that gets them to think about the dispute in a different way, about how their story might land differently than the story they've been telling themselves. And So to do that, I often get help from our jury consultants, who are, extremely important consultants throughout the litigation process and really good at coming up with some of those concise and compelling ways of communicating key points. So another story, many years ago, I had a mediation in a case that involved a car full of teenagers driving into a telephone pole. So very tragic and sympathetic case. Again, all the arguments were about whether the pole was too close to the road, if it was not visible around the bend, and if there had been accidents there before and the company should have known to move the pole and so forth. And I did some research, which has actually haunted me for years, especially since, I've now had 3 teenage drivers of my own. But I did research on the risks created by 16-year-old drivers and brought a very compelling chart to the mediation about the risk of accidents caused by 16-year-olds, which is terrifying. It's higher than drunk drivers, distracted drivers, cell phone using drivers, and even higher if they're male, and even higher if there's several in the car, and even higher if it's Saturday night. So the chart was just a real eye-opener, and it wasn't personal, it wasn't throwing the kids involved under the bus. It was just a comparative risk of having a car full of 16-year-old boys driving a car on the road anytime, anywhere in the US versus where the telephone pole was located. So, we consult with our jury consultants early and often. They help with theme development, graphics, charts, and particularly if we're late in the case and we've actually done a mock jury exercise, the insights from that can be super helpful in preparing for mediation and thinking about how to present our story to the plaintiff, in a way they're actually really going to hear and that will sink in. So I actually had a situation like this where we were a couple of weeks away from trial, and we had just done the mock jury exercise, which had resulted in 3 defense verdicts, all for the same reason. And that's kind of an unusual outcome, right? I mean, you've got 3 different mock juries. They're likely to come to different conclusions, or if they all reach the same conclusion, it's not going to all be for the same reason. There's a certain amount of randomness in, how juries think about things. But these 3 mock juries at all come to the same reason for why the company should win the case. And so I thought we put together a pretty compelling communication to the other side around that narrative and reason why we should win. And it ultimately didn't convince them. So at the end of the day, we said, well, should we tell them that we got these 3 defense verdicts? Not normally something you would share with the other side, right? Because that's privileged confidential information, really for the defendant's use only. But we reached the conclusion that fact, if they knew it, might really change their mind, and the mediator agreed. So we agreed on terms to share it with them and told them that. And that actually did help us get to a settlement in that case. So I've never done it again, but it was effective. So let me pause there for a minute and see if there's any more questions. I have a couple other things to cover, but just want to make sure I'm not ignoring people that.
Cynthia, I have a question for you. Do you ever use formal risk analysis, either when you're reserving for the case, when you're coming up with the strategy, or even in talking to plaintiffs, where you try and introduce kind of probabilistic thinking and expected value?
Yeah, before, no matter what stage I'm mediating a case at, I want to have some objective basis for the authority that I seek, especially if it's authority that I have to go up the chain for, right? So, I don't just send an email to finance saying, hey, can I have 10 million bucks? I think it's a good deal. I'll want to have some kind of analysis of what the claims are and who are the key witnesses, and what is the jury verdict landscape look like in this particular area, and and I'll have outside counsel do that as sort of step 1, and then I'll have my own gloss on top of it, including some of the things that are specific to us as a company or this dispute, concerns that we might have about the risk that you wouldn't necessarily know about from an objective analysis or from a case specific analysis. And so, yes, I still think it's, some of it's guesswork, some of it's anecdotal. I mean, there is data that goes into that, but it's also, at some point we have to get to a number that will actually get this deal done, right? So, but yes.
And one other quick question, you talked about early when a case is ready for mediation. What do you think are the characteristics of when it's ready? And why wouldn't you try mediation always just at the beginning of a dispute? Kind of flip side of the same question.
So I do like early mediation. As the years have gone on, I like it more and more. But I think before the other side's ready to mediate, there's often some process that has to have gone on, whether we've litigated a motion to dismiss or there have been other preliminary proceedings that have kind of put the parameters of the dispute out there. And then for us, have we done the internal work? Have we looked at the documents? Have we interviewed the witnesses? Have we, gotten a sense of what what were the drivers of the dispute and how we could justify our conduct, and is this discovery going to be good, bad, terrible? Usually it's not good, right? It's somewhere between, not because the company did anything wrong, just because discovery is always terrible, and use that to evaluate the risk in a more objective way.
Thank you.
Cindy, I have a question for you.
Yeah.
You talked about reevaluating the dispute during the course of the mediation, and of course that's part of what the mediation is for, to provide new information and new perspectives. What are some of the things or approaches or interventions that mediators do that you have found particularly effective? And what are the things that mediators do that really turn you off?
Good question. So I think when mediators are really effective at influencing my thinking about the case is when they identify something that maybe we haven't focused on or that I haven't focused on, and provide an explanation based on their own experience or the sort of the broader landscape for why that's something I should pay more attention to and why that makes the value of the case higher than I might think it is. So, I really listen to that. And also that gives me good talking points if I need to go back up the chain and say, hey, I need a little more money and here's why. Here's something I didn't think about before that has made me reevaluate this dispute. What really burns me in a mediation is if the mediator is just focused on horse trading, really just back and forth with the numbers and not really willing to engage in the substance in a way where we have the opportunity to provide, through the mediator, persuasive reasons to the other side, and then the mediator brings back from the other side reasons that are persuasive to us, right? Which I think is really a much more compelling format. I have been in mediations where the mediator thinks his or her job is to bang heads and, and just trade numbers. And I just find that less effective.
What does that mean, banging heads? How does it manifest itself? And why is it such a turnoff?
You're going to walk away with nothing, or, your CEO is going to be deposed, or, the jury's going to give them millions of dollars. I'm a rational person and I really like to deal in rational ways, recognizing there's a lot of emotion in disputes, but I don't want the mediator to try to scare me or the plaintiff into accepting numbers that are arbitrary. I want to get there in a rational way.
And then in terms of bringing to your attention things you might have overlooked or not put into context, you come to mediations well prepared. As you say, there's been some process before the mediation, and you have outstanding lawyers from fine firms representing you, I'm sure, in all these cases. How often is it the case that you are in a mediation and you go, we never thought of that?
Yeah, more often than you might think, and not because we never thought of it. It's probably in there somewhere. We just haven't focused on it in the same way.
Okay,
You see Maggie
Maggie
has her
Montgomery.
hand up too.
Yeah, Maggie, please ask your question.
Oh, is it? Hi, can you hear me?
I can.
Yes.
Okay, great. Yeah, I was just wondering, when you have the other party in the mediation making demands that are just completely outlandish, and also they have no support, evidence-wise, or any court could possibly construe that their demand would be reasonable, yet, they don't back down, and even the mediator says, well, I don't know why they're making this dollar amount demand, and I don't see how they're substantiating it. And so, you kind of have wasted, because even just going to mediation can cost like $5,000, $10,000. So you've wasted that money, and then the other party doesn't have a reasonable basis. Do you have any suggestion of how to get through to those people?
Yeah, no, I mean, it's a good question, because sometimes you do have that situation. I mean, I find that if the plaintiff has agreed to mediate, they're at least open to the concept of a settlement, and their lawyer may want some help from me and from the mediator in, getting the plaintiff to a place where they're willing to settle. Because, if both the plaintiff and the lawyer just want to go to trial and roll the dice, they're not going to be there, right? So, part of breaking through that is, having really reasoned points to carry back to the room. And part of it is really trying to get to the bottom of what's driving the dispute, and what is in it for the plaintiff to be insisting on a number that isn't realistic and isn't going to happen. And they should know it's not going to happen, right? And so what do we need to work through to get them to a place where they're going to consider a number that is reasonable? And, sometimes there can be other terms that can be part of the settlement that help get there. And sometimes they're really weird. You don't know until you start talking about it, what actually might be valuable or meaningful to a plaintiff. And I've had some really strange ones. But things like, is there some ongoing business relationship that might be a possibility? Or maybe the plaintiff wants to be able to refer to the work they did with the company on their website, or they want access to some hard to get product or event or something like that. Apology letter from leadership. I've gotten that one a few times, and then I'll go up to the leader and say, can we get an apology letter? And they're like, no way, I didn't do anything wrong. And I'm like, well, it's hard to write an apology letter, but it's much harder to be deposed. So, can we get there? Or the weirdest one ever, I think, is there was an employee who was her father had worked at the company too, and ultimately what helped close the deal with that person was having a painting in one of our buildings that was dedicated with a plaque to her and her dad for their service to the company. So still hanging.
Wow, that's very creative. And so one thing I consider in this specific situation that I'm talking about would be, I'm seeing more and more attorneys take cases based on a contingency basis. Traditionally, that was mainly for tort law. And now you're seeing it in other. And so this specific case I'm talking about, the attorney has taken the clients on a contingency basis. So, that made me think maybe and clients are, laymen aren't versed in how a court's going to construe evaluation or things like that. So one thing I considered is maybe this attorney is just, kind of made up this number because it's a contingency case, and then wants to get as much as they can. And they aren't really, maybe being that intelligent in this assessment, because, yeah. So just dealing with like those
That's
nuances.
where the mediator can really help, right? Because mediators have so much experience and can so much skill and value in cases, and really have an opportunity to speak directly to the plaintiff about how to think about the value of their case in a way that their lawyer maybe has dug himself or herself a hole, in terms of being able to do that, have gotten the plaintiff stuck on a number that ultimately isn't realistic. And so, I think that's a reason why some plaintiffs' lawyers go to mediation, is so that they can offload that task onto the mediator instead of doing it themselves.
That's great advice. Yeah. And like you said, I do let our outside counsel handle things, but sometimes, I'm kind of supervising the situation and in the back of my head, just thinking this is outlandish.
Yes. Those cases often ultimately settle no matter how crazy they are at the outset. So Bob, I see you have your hand up too.
Thank you.
A couple of things. First, Cynthia, I appreciate your insight and comments. The one slight disagreement was when you said that you didn't always feel like your outside counsel and your financial interest were aligned. My experience as a defense lawyer was, if I got a case settled, there was a lot better chance I was getting some more work from that client.
That is absolutely true. And
I love
my outside counsel. They are fabulous and they do wonderful work for me, including settling lots of cases. But go ahead.
The other part of it is, to me, is as a mediator trying to get the lawyers on both sides to get their egos out of the way. Because as you said, resolution is a win. And the other part of it to me is, and we're seeing more of this, I am in Florida, rather than mock juries, is defense counsel during the opening session talking about the fact that we can all watch. We used to say read the same book, but we don't read books anymore. Watch the same streaming video and have different views. And to me, getting the plaintiff to understand, and for the plaintiff to say to the defendant, I know that's your version, but those 6 people have no input into it. But to me, as you said, the resolution is a win. Yeah, I want to do the best for the client, but in my years, and I did a little bit of plaintiff, I don't ever remember after a trial having a client say that was a lot of fun, I want to do it again. And I think getting that across to both sides, they don't want to be deposed. My corporate rep doesn't want to be deposed. If they've done it before, they really don't want to do it. And to me, a lot of it is, like you said, getting everybody to say, the goal here is to get this over with. Let's be open-minded and realize those 6 or 8, 10, 12 jurors may see things very differently from all of us. I appreciate your insight.
Thank you. So the last point I wanted to make, and this has really become important to me, especially in recent years as this practice has gotten more common, is I really love the mediator's proposal. So if we get to the end of the day and we haven't gotten to a mutually agreeable solution, I think it makes all the sense in the world to ask the mediator to make a proposal. And this is just, I have found an incredibly helpful tool that has gotten a lot of cases settled that wouldn't settle otherwise. And it's useful to corporate counsel for so many reasons. First, because it's a blind process, right? If I say yes and the other side says no, they never know I said yes. And so it doesn't become a floor. And that really eliminates the biggest concern with going to the limit of your authority at mediation. If you're not certain that's going to actually settle the case, it just becomes a floor. And then you have to go back up the chain and say, oh, hey, I said the case was worth X, but now we need X plus 10. And that's always a little bit challenging for in-house counsel. So it doesn't become a floor. And then, if the mediator's proposal is within your authority, great. If it's not, it gives in-house counsel a really elegant way to get more authority. So instead of going back up the chain to say, hey, I need more money than I previously told you this case was worth, you say, we went through this process. Some things were called to my attention that I hadn't focused on. This very experienced neutral mediator opines that this number would be a reasonable resolution, and I think we should accept it. And so that takes some of the weight and responsibility off the in-house lawyer for justifying the number. And then, for the reasons that Maggie and I were just discussing, it's a helpful tool for plaintiffs' counsel to use with difficult plaintiffs who may be thinking the case is worth a lot more. To have this third party, actually, this experienced, credible third party, put a number on it, that just makes it easier for plaintiffs' counsel to get the plaintiff to that place. And then, finally, the number kind of takes on a life of its own, and no one has to feel like they won or lost with the mediator's proposal. It just has this inherent neutrality. So I love this. I wish all mediators would do them. And, I think if this became a really well-accepted practice, more cases would settle. And so I push for it, even if it's not something the mediator offers. And then, in any event, whether there's a mediator's proposal or not, at the end of the mediation, if the case hasn't settled, I really like to ask the mediator to stay involved or to be open to further discussions, or, being pulled back in, so that we can, take advantage of, get good use out of the credibility that the mediator established with the plaintiff, that I may have established with the plaintiff, and the progress that we made during the day. And, if something changes in the litigation and there's another opening, we can all kind of snap back and give it another go. And often that works, right? We settle the case on round 2 or even round 3. And at the end of the day, whether we've settled the case or not, whether we have a mediator's proposal or not, I just like to, again, speak to the plaintiff directly and say goodbye and thank them for their time, and say, I hope we can keep discussing a resolution, and really like ultimately to resolve this dispute, and I'll keep the door open to keep talking about it. So that's what I have. Yep. Happy to answer any more questions.
Yeah, Cynthia, thank you. This is just tremendous. Let's dig in a little bit on the mediator's proposals. If a mediator's proposal is not accepted by both sides, it can really cause a lot of problems in the mediation, right? Because if one side has said yes, all of a sudden that mediator's proposal is imbued with a divine sanctity, and it's very hard to get that party, once they've said yes, to go up or down from that number. So what are the things that you like to do in a mediation to protect yourself from a mediator's proposal backfiring, and to heighten the chances that the mediator's proposal will actually be accepted?
Well, so I, over the course of the day, I of course want to have some influence over how the mediator's thinking about what the number might be that is actually doable from my side, right? So I'm not going to get a mediator's proposal that is 2x my authority, right? So I'm trying to lay that groundwork over the course of the mediation, not just with our negotiations, but with the rationale for them and all of the work that we're doing. And also, of course, trying to get a sense for, what the plaintiff's bottom line is and how much flexibility there is there. And the mediator is always going to have a lot more information about that than I do. But often, by the time we're towards the end of the day, I can predict the range where a mediator's proposal might land, and start to think about whether that's something that either I can do immediately or can justify, getting additional authority to do. And, I have had cases where the mediator's proposal is not accepted, including one in which I guess the mediator hadn't explained it well enough, and the other side really didn't understand it. And but generally they've been extremely effective in my experience in getting cases resolved. Even if, again, it's not that day, maybe it's a day later or 2 days later or a week later.
And do you ask mediators to make a mediator's proposal?
I do. I do.
If you've had progress and you've kind of squeezed it together, but you still have a last gap? Do you find mediators' proposals are ever effective if the parties are, one side is way up high and the defense is way down low, and there's still a huge gap to be traversed?
Yes, they can be. And sometimes, I'll ask and the mediator will say, well, I don't really want to do it because of this huge gap. And there'll be sort of a conversation of dancing around, maybe where it might be. And then I could say, okay, well, never mind then, or let's give it a go. It does take on a life of its own, but I don't, it doesn't mean the case won't settle for more or less than that. But it's just helpful, I think, more than anything, in taking away the sense that either party won or lost in the mediation.
And then how do you protect yourself from the mediation devolving into a situation where people are holding out at more extreme positions, gaming the mediator to make a mediator's proposal that's closer to their position than yours or your position to theirs?
I think mediators don't fall for that generally. I think they can see game playing, and I again try to be very reasonable and credible throughout the day, and so the information I'm communicating and justifying to the mediator is real, right? And so I tend to think that if the other side's not doing that and it's just pulling these numbers out of thin air, that's not going to influence the mediator to overprice the case. We've there's just the mediator population that I work with is really just excellent. There's a lot to be said for years of experience resolving disputes.
So true. We have just a minute or two left, Cindy. Are there any last words of wisdom? Anything you haven't said? Well, we have one question here from Sang-Yoon Lee. So if you'd please unmute yourself and ask your question, that would be great.
Yes, Cynthia, thank you so much for speaking with us. I'm currently a 3L joining a mediation clinic. And first of all, thank you for all your great words of advice. But I wanted to ask, for someone without mediation experience, do you have any advice, just things that I can prepare going into mediations? I'll obviously be sitting with an attorney and they'll be assisting, but any pieces of advice or things that you think would be helpful in preparing going into sessions moving forward?
Yeah, I think, I would advise you to take the key facts and law in the case that you would present in litigation and try to humanize them and take the emotion out of them or take the negativity out of them and find sort of compelling ways to present your points that are going to resonate with the plaintiff without making the plaintiff feel defensive or attacked or undermined or that it's an adversarial process.
Thank you.
Thank you, Mr. Lee. Any other last minute comments, words of wisdom, inspirational thoughts for us, Cindy?
Well, thank you all. Thank you to the mediator community for all the great work that you do, which is tremendously beneficial to corporate defendants, I believe, and I find very useful. And I really enjoy mediation. I think it's an extremely rewarding process. And so, thanks to everyone.
And thank you for your strong support of the mediation community and the mediation process in your role at Microsoft Corporation. It certainly has an influence on the acceptance of mediation and good mediation throughout the corporate world. So thank you for that. I know that I'll be contributing to Northwest Harvest in your honor. That's northwestharvest.org, northwestharvest.org. Cynthia Randall, thank you so much for an outstanding presentation. On behalf of the whole Will Work for Food team and our large audience for this, we really appreciate it. And with that, we are complete.
Thanks, everyone.
Thank you, Cynthia.